Wanju. Hello and welcome. My name is Shamit Sagar. I am the director of the University of Western Australia Public Policy Institute, located here in Perth on the west coast of Australia. You're very welcome to join us from wherever you are across the world for a live webinar dealing with modern slavery, taking us from reporting to human rights and due diligence, global trends in business and human rights. Can I begin, as is our custom at UWA, to acknowledge the fact that we are located on the land of the traditional land of the Noongar people. This land was always theirs and remains theirs, and it is something that I'm very proud of the fact that from pre-colonial and pre-European times, it was a place of learning for the Noongar people and carries on being so. So it is entirely appropriate the university is talking to you with our panel from here. The University Public Policy Institute has been around since 2019. A quick word about it. It is in common with many research-intensive universities right across the world that we put our mind to the extent to which our research is translated in a timely way and put in the hands of decision makers, whether in government, business, non-profits, campaign groups, or what have you. And so one of the things that we do is to make sure that precisely that job is done across the university, and we partner with a number of our research colleagues, 1,400 of them no less at this university, not all of them at the same time, and put together webinars, publications, public events, private roundtables, and so forth, in order to make sure that these key issues are shared with as wide a possible group of practitioners as well as the wider public. So this evening, we're dealing with modern slavery, both here in Australia and internationally. We're delighted to be collaborating with UWA Law School, and in particular, Professor Fiona McGoffey and the Modern Slavery Research Cluster that she is a part of. It's not for the first time we've looked at this issue with her and her group at the university. To very quickly recap, and I'm just going to spend a minute or two on this, you'll be familiar, many of our participants, with the fact that here in Australia, legislation was passed back in 2018, dealing with modern slavery, and part and parcel of that legislation was a requirement, an expectation, but actually a formal requirement that a statutory review would take place after the first 3 years of the legislation. This is a very effective feature of modern legislation, where a review about the impacts and intended outcomes, and for that matter, some of the unintended outcomes, is picked up and is required to be picked up as part of a review 2 or 3 years after a piece of legislation has been enacted. The 2020 National Plan in particular set the date for that, and that review, I think, as I understand it, has started earlier this year, in March of this year, and it runs for 12 months, so we're more than halfway through that period. As you would expect, that the scope of the review is going to be looking at the reporting requirements, the reporting threshold set at $100 million, the need or otherwise of an independent commissioner to oversee the implementation, the further implementation of the Act, and of course the relevance of international experience as well as best practice. These are many of the things I'm sure that the discussion will get into, and it will be chaired by Fiona in a moment. Can I just ask you to, if you're going to be participating, to use the Q&A function. Fiona will be chairing. There'll be many people who've tuned in right across the world and across different time zones, so it's important to try to have an effective discussion and a debate across the participants as well as the audience. Nothing more from me at this stage. Fiona, I'm going to hand directly over to you to take us forward. Thank you.
Thanks so much, Shamit, and thank you to the Public Policy Institute here at UWA for your support in hosting this event. I'd also like to start by acknowledging the Whadjuk Noongar people and pay my respects to their elders past and present. So we're very pleased to be able to bring this stellar lineup to you this evening. The topic of human rights due diligence laws has really come to the fore in Australia in the last few years, and in particular there's been a real interest in developments in other jurisdictions, and this is particularly timely, as Shamit has said, because of the current review of the Modern Slavery Act. So we thought it was timely to have this discussion and to hear from a panel of experts, including academics, business, civil society, all of whom have particular practical experience and research experience in this area. So I'm going to go ahead and introduce the panel. We probably speak for about 40 minutes, and then I'll try to leave quite a bit of time for Q&A afterwards. So if a question pops up for you as we're discussing, feel free to put it in the Q&A, as Shamit has said, and we'll certainly try to pick up as many questions as we can. So to introduce our panelists, I have Gabrielle Holly, who's a Senior Advisor in Human Rights and Business at the Danish Institute for Human Rights. She leads the Institute's work on policy and regulatory developments of relevance to business and human rights, including the trend towards mandatory due diligence laws. And prior to this, she worked as a legal practitioner in Perth and in London, specialising in commercial litigation and business and human rights. And she's also been a researcher in business and human rights at the British Institute of International and Comparative Law. Gabrielle actually studied here at UWA at the law school, so virtually you're very welcome back, Gabrielle. Next we have Tegan Hoddy, who is the Director of Responsible Sourcing and Sustainability at Alcoa. Tegan is responsible for the development, execution and management of Alcoa's global supply chain sustainability and responsible sourcing program, which includes work in the area of human rights, risk management, due diligence and product life cycle. Tegan has also had positions in the past at Rio Tinto, BHP and Woodside. Next, we have Freya Dinshaw, who is the Acting Legal Director at the Human Rights Law Centre in Melbourne, specialising in business and human rights. Freya's work focuses on exploring opportunities for deploying advocacy, strategic litigation and international mechanisms to challenge the treatment of vulnerable communities by governments, companies and other actors. Next, we have John Southeyland, who's a barrister and an adjunct professor here at the UWA Law School. John has published and presented on topics including human rights in business, mining regulation, climate change, Indigenous rights, minerals taxation, CSR regulation, and mining agreements. He is also an independent examiner for, it's no longer called the Australian National Contact Point, I believe, but John can correct me when he comes on, for the OECD guidelines for multinational enterprises. And lastly, we have Serena Grant. And Serena is Head of Business Engagement at Walk Free within the Minderoo Foundation and is part of the Secretariat of the Bali Process Government and Business Forum. Serena has previously worked as a corporate lawyer in London, Sydney and Tokyo, and most recently as a director at the Thomson Reuters Foundation in London. So I'm sure you'll agree, an excellent panel of experts with us here this evening, or whatever time it is with you. I'm just going to kick off. Freya, I'm aware that we probably have a range of expertise in terms of our audience. So I thought it would be useful to just start with a discussion of what we mean by modern slavery. And if you could also tell us a little bit about how the Modern Slavery Act works here in Australia.
I think a lot of people, when they hear the term slavery, think, but that happened a long time ago in the past. So that happens in other places. But actually, research shows that now more than ever before, we have the highest number of people trapped in conditions of modern slavery across the world, and that this happens in all places, including right here at home in Australia. And what we mean when we're talking about modern slavery is we're talking about people who are working against their will, who are trapped in labour, whether it's because they're in conditions of debt bondage, they're paid to have a job and they can't get out of it, whether it's because of their vulnerable status, perhaps they're a temporary migrant and all their papers have been taken and they can't leave the job without relinquishing their paperwork, or there's a variety of different indicators of modern slavery that we see in different contexts. We know that more vulnerable groups, particularly migrants, women and children, are adversely affected, but it's a problem that is really serious and affects many of the supply chains that we rely on for the food that we eat, the clothes that we wear and the products that we use every day. So 3 years ago, as has been said, the Australian Modern Slavery Act came into effect. And when it was enacted, it was meant to drive a race to the top by businesses by essentially requiring very large businesses with over a threshold of 100 million per year to report on what the risks of modern slavery were in their operations and supply chains and what steps they were taking to address those risks. But what we know is that and what I think isn't that well known about the Act is if a company fails to put in a statement or puts in an incomplete statement, a misleading statement, or has links to modern slavery in their supply chain, essentially the Act doesn't actually have consequences or ramifications for those companies. And so it's been seen as a law that could be strengthened, and the review at the moment is a perfect time for that. Some of the research that Human Rights Law Centre has done together with a number of academic, civil society and church groups found that in the first round of reporting, 77% of the companies that we reviewed from high-risk sectors failed to meet the basic mandatory reporting requirements of the Act, that over half failed to identify obvious modern slavery risks in the sectors that they were sourcing from, and just 27% could demonstrate any form of effective action to address those risks. And so what we can see is that there's a long way to go in terms of driving real change to the conditions that we know are in the supply chains of our companies here at home.
Thanks so much for that really excellent summary. It's very hard to be concise about this, but thanks for that. And yes, I see someone has agreed with your comment on the disproportionate impact on women and children, which is a really important point to remember. I'm going to move now to our business representative, Tegan. And perhaps, Tegan, it might be useful for you to tell us a little bit about Alcoa, for those who may not be familiar with the company. And tell us how the Modern Slavery Act has impacted your organisation and what you do to comply with the Act. Thanks.
Thanks, Fiona. Alcoa is a global aluminium company. We mine bauxite, process alumina, and then manufacture aluminium in numerous forms across several locations around the world. That means we have large, extended, and sometimes very complex supply chains. The Modern Slavery Statement in Australia has really given us the opportunity to pay more attention. And it's important. I think several years ago we started on this CSR kind of journey. It was raised at a board level that we were engaging with suppliers in certainly higher risk jurisdictions, or the perception of higher risk jurisdictions at the time. And so we started to make progress and inroads into how do we put some due diligence and some structure around that. It was very targeted. Then the Australian Modern Slavery Statement came along. We have a good proportion of assets here in Australia, and that really meant that we had to dig a little bit deeper and expand how we look at risk and where that risk actually sits. And so we wanted to find a third party to partner with. We went down that path to help us, one from a resource, but two from a knowledge perspective. And also the fact that a lot of what we purchase, while it may be from an Australian entity, it certainly does come from overseas when you look back through that supply chain. So the Australian Modern Slavery Statement really gave us that, I guess, acceleration or need to have a focus to look a bit deeper, understand the environment that we are looking in, and what we can do and how we can understand it.
Thanks so much, Tegan. And I think, the complexities of supply chains is something that people often speak about. So that's really useful to get a sense of that. And also that the use of external expertise for knowledge, because it was one of the things, again, that has come up in our research, that often people would have liked more supports or training or resources. So thanks for that. And I'm going to come back to you later. Gabrielle, so Freya has kindly explained modern slavery. So I want to move to the next sort of part of our discussion, which is human rights due diligence. And, this is something that we've certainly seen a significant trend, particularly in the last few years, with a number of domestic European jurisdictions having human rights due diligence laws, but then also this proposed EU Sustainability Directive. But it would be really helpful if you could start by telling us what is actually meant by a human rights due diligence law.
Yeah, absolutely, Fiona. And hello from Copenhagen. And thank you as well for the warm welcome back to UWA. So maybe before we get into the mechanics of human rights due diligence, I think it's worth reflecting for a moment on what it aims to do. So the company's impact on the enjoyment of human rights in a range of ways. And I think what often comes to mind are labor rights and the worst forms of labor abuses that Freya walked us through a moment ago, like modern slavery in supply chains. But companies can impact on a broader range of rights and impact a broader range of people and communities and consumers. And so what human rights due diligence ultimately aims to do is provide a way for companies to understand the impacts that they have and address them effectively. So it's a process that was developed under a key international soft law instrument called the UN Guiding Principles on Business and Human Rights, the UNGPs for short. That was the kind of foundational instrument that we use in the field of business and human rights. And it was sort of supplemented by other instruments like the OECD guidelines, which expanded this process of due diligence to not only consider human rights impacts, but also environmental and governance and other responsible business conduct issues. So what the UNGPs does is it outlines the duties and responsibilities of states and businesses, respectively, with respect to human rights and the shared responsibility of those actors to facilitate effective remedy where harms occur. Under that framework, states have a duty to protect against human rights abuses, including by business enterprises, and they do this largely through enacting and enforcing regulation. Businesses, in turn, have the responsibility to respect human rights, and the use of the term responsibility here is quite deliberate to indicate that it's not an obligation on par with the state duty to protect under international law. At its core, human rights due diligence is fundamentally a means by which a company can discharge this responsibility to respect by understanding the actual and potential impacts, the negative impacts that it can have on the enjoyment of rights and taking action to prevent or mitigate them. So it's a 4-stage risk management process, essentially, by which a business firstly identifies the impacts that it has on human rights, and it should do this by consulting effectively with stakeholders. It should take action to address them. It should monitor the effectiveness of the actions that it's taking, and it also should communicate about its due diligence process and the impacts that it's managing in what we sort of call a know and show model, essentially. The process very much takes inspiration from the more widely understood process of corporate due diligence, which might be conducted in the course of a transaction, but it differs in a few quite key respects. So firstly, it's iterative. It requires a company to conduct an ongoing process of due diligence rather than a kind of one-off due diligence exercise that you might conduct in the context of an acquisition or entering into a new market. But more fundamentally, instead of focusing on risks to the business in the due diligence exercise, a company is required to consider how its operations and how its business relationships impact on the enjoyment of human rights of a wide variety of rights holders, so workers in the value chain, communities and consumers. And in this way, rights holders are very much placed at the center of this due diligence exercise.
Thanks so much, Gabrielle. I was taking notes as you were speaking. That was really useful. Thank you. Could I follow on from that then, Gabrielle, with you and ask you to give us a bit of an overview of these developments that we're talking about? What are the trends that you're seeing in terms of new laws, either proposed or already in place?
Yeah, absolutely. And there's a lot going on, frankly. And so I'll give you a very quick account of what's happening right now and maybe a quick run through how we got here. But of course, I'm happy to field any questions about the sort of nitty-gritty of each of these laws that I'll cover in the discussion portion. So the UNGPs were adopted unanimously by the Human Rights Council in 2011. So we now have a decade of companies engaging with the UNGPs implementing human rights due diligence. My institution, the Danish Institute for Human Rights, has been working on this agenda for 20 years. And over the years, we've worked closely with corporate partners to help them implement due diligence. And while there are, of course, challenges, I think Tegan alluded to the complexity of global supply chains, which is an ongoing challenge, but we've seen meaningful engagement and some developed practices among leading companies. And in parallel with this kind of voluntary adoption of due diligence practices, we're also seeing the soft law responsibilities in the UNGPs starting to harden and be translated into legal obligations through a number of instruments that we've seen enacted at the EU level, or sorry, within the EU rather. But this has very much been an evolutionary process. So the first of the laws in this family of laws was the one that the Australian MSA was based on, the UK Modern Slavery Act, which came in 2015. So like the Australian Modern Slavery Act, it didn't oblige a company to take any particular action to manage modern slavery in the supply chain, but rather it required reporting in the form of a modern slavery statement. And there have been various studies on compliance with the requirements of this in the UK, and I think they align quite closely. The findings align quite closely with the findings that Freya's just referred us to about the sort of the quality of compliance with the requirements of the law. And I think that there's good evidence. I think as Tegan said that these modern slavery acts have elevated these issues to board consideration, and there's been a lot more awareness about these kinds of issues. But I think there are real questions about whether or not these laws have materially impacted rights holders and really improved the conditions of workers who are labouring under conditions that amount to modern slavery. And so in the last few years, there's been an evolution from modern slavery acts to laws which actually require a company to undertake a form of human rights due diligence, as envisaged by the UNGPs. The first of these was in France, which came in 2017, the Loi de Vigilance. And this was then followed by initiatives in Germany and the Netherlands and Norway, which have aimed to translate the kind of requirements of human rights due diligence in the UNGPs more fully. And so now we have a proposal for an EU level directive, which was published in February this year, which would require companies to conduct due diligence in line with the UNGPs and OECD guidelines. And this is the most wide-ranging and ambitious of these laws so far. It will require all large EU companies and certain non-EU companies to conduct human rights and environmental due diligence across their global value chains under the supervision of a regulator, and additionally enforced through a civil liability mechanism. Over time, this will be extended to medium-sized companies in what are termed high-impact sectors. Those are textile, extractive, and agriculture. And now the final law is still in the process of negotiation, so we don't know exactly what it will look like in the end. And there are a number of key issues to be resolved. Of course, I'm happy to touch on that in the discussion portion. But suffice to say, we will see an EU-level directive in the next 2 years or so. And once agreed, all EU member states will be required to transpose the requirements of that directive into their own national laws. So companies will need to conduct due diligence in accordance with this 4-stage process, identifying impacts, acting, monitoring effectiveness, and communicating in a manner which meets the expectations of these laws, under threat of administrative sanction or potentially civil liability for harms which occur as a result of a failure to conduct due diligence in line with the laws. And so potentially this has a huge impact, not only in the EU, but potentially on any entity which forms part of the global value chain of one of these companies that are directly captured by the law, because the due diligence obligation extends throughout the global value chain. And just before I hand over the mic, I think that just want to make a point that I think there's a misconception that EU businesses are homogeneously opposed to regulation in this area. I acknowledge that there's certainly been some lobbying from certain business associations, but I can direct you to a number of company statements from groups of companies who are really calling for these laws and to be enacted. And I'll put a couple of links in the chat for those who are interested in seeing those.
Thanks so much, Gabrielle, and so many developments. And it's really interesting that you say we don't know exactly what will be in the directive, but we will have a directive, and there's going to be that trickle down effect to Australian businesses and others. I think it's a really significant development because of the potential scope. So thanks for sharing that. And yes, really useful if you do want to share anything in the chat, and other panelists, of course, feel free to do the same. So I'm going to briefly, Freya, just go back to you. Given that we hear about these developments across Europe and that they are based on the UNGPs, which is kind of, the most authoritative international source that we have in this area alongside the OECD guidelines. What does that mean for Australia? I mean, do you think this type of approach is relevant here? And what are the options for us?
Thanks, Fiona. And you know, at the moment, Australia is in trade negotiations with Europe. We do trade across Europe. And so the kinds of requirements and laws that Gabrielle has been describing are going to affect a number of Australian businesses. And so the current review of the Modern Slavery Act that we have at the moment is an opportunity to really ready Australian businesses, I think, for the inevitable direction of traffic, which is towards human rights due diligence obligations that require companies to take action to identify their risks, mitigate their risks, and ensure that any people who are impacted by their actions have some access to remedy. And so in the Australian modern slavery context, what we would like to see is due diligence incorporated into the body of the Act. And we've looked at a few different Australian legislative models where we have due diligence already, due diligence obligations on businesses, mostly in relation to corporate issues. But we think that the sort of simplest way to do this would be to include a duty to prevent modern slavery with a defence of due diligence, where companies can demonstrate they've taken reasonable steps to prevent modern slavery in their supply chains. And so in that way, there would be a floor set that businesses have to do the bare minimum to ensure that they're identifying those key risks in their businesses and taking action to address those risks. Otherwise, there would be consequences. And I think that that is, we can take a lot of inspiration from Europe and New Zealand and other countries that are exploring due diligence measures in developing the approach here as well.
Thanks so much, Freya. And yeah, that duty to prevent approach was one of the solutions offered by the Australian Law Reform Commission in their corporate criminal responsibility report. So it's you know, it's quite well established and it's supported by research. So that would be a really interesting one to see whether that might be taken up here. Serena, I'm going to move to you. Obviously, Walk Free is, you know, the leading international NGO in the anti-slavery space. And it would be really interesting to hear what your position is on whether moving towards a human rights due diligence model is a good option. And I'm also aware that recently you've published the global slavery estimates with at the ILO and IOM. So also you might feel free to give us an update on that.
Sure. Thanks, Fiona. Yeah, I think, look, in short, we do think moving to a due diligence model here in Australia is the right way to go. You know, I think it's been summarised really well by Gabrielle and Freya in terms of the effectiveness of the current Modern Slavery Act. You know, we've been reviewing Modern Slavery Act statements in the UK and in Australia for 6 years now, and like many other organisations have found them to be pretty lacking. You know, I think our stats across that 6-year period show, you know, less than 50% compliance with the basic requirements, and very similar, I think, to what others have discussed in terms of not identifying specific risks, let alone taking action to address those specific risks. And I think there's a real danger with any legislation like this that it just turns into a policy, strategy, compliance exercise where you've got some beautiful policies in place, you're maybe running some risk checks over your supply chain, but you're not actually doing anything to reduce the risk to people, the most vulnerable people, which is what the Act is all about. So yes, I do think that moving from a pure reporting requirement like we have now to one that actually requires action is essential in this review of the Act. And, you know, I think that's our number one advocacy position is really trying to get that in there. I would say it's not as scary as it sounds. The way the Act is drafted and the way the guidance is drafted is very much based on the United Nations Guiding Principles on Business and Human Rights, as Gabrielle was mentioning. And, you know, the way it describes due diligence and undertaking that process is very aligned with the due diligence model. It's just that in the mandatory requirements of the Act, it's not saying you have to do this, it's saying you should probably report on this. So that's really the change we'd like to see. I think the businesses that are already reporting under it and already reporting well are already doing that. So it's really just taking that next step to say, okay, identify your risks well, make sure you're actually taking action to mitigate those risks. And we have seen examples here in Australia where businesses have identified risks very clearly in their statement, but then haven't really taken any action. And I think that's where we really need to step in and start enforcing the Act. So I think two big things there. One is, yes, there should be an obligation around due diligence, and the other piece is, well, how do we enforce that? And I think we need to think about things like disbarment from public procurement, penalties, liability, directors' liability. All of those things should be on the table. Again, within reasonable boundaries. I think, you know, a model that shows where you've conducted adequate due diligence, you know, it is complex, and we do need to have some reasonableness requirements there. So yeah, that's what we would ultimately like to see. And yeah, you referenced our recent publication, the Global Estimates of Modern Slavery with ILO and IOM, and you know, that showed that the current current estimate of the number of people in modern slavery globally is now 50 million, and that's an increase of 10 million people since we published the last estimate 5 years ago, and that's outpacing population growth. So that's actually an increase in prevalence. So really, you know, I think that underlines the need for businesses really to take quite urgent action to do something about it.
Thanks so much, Serena, and in particular for sort of demystifying how we might move from something like the Modern Slavery Act to what sounds like something quite different, but actually is almost just a step along the same path, if that would be fair to paraphrase. I think that's a really good way to look at it. John, I'm going to move to you. I know Gabrielle has pointed out that some businesses are actually really supportive of these types of laws. I know before the Modern Slavery Act was introduced in Australia, there was often a discussion about creating a level playing field, and some, you know, large organizations being really supportive of this type of law. But there'll also be businesses who have concerns. And so as someone who's familiar with the UN Guiding Principles and the OECD guidelines and your work, do you see potential benefits for businesses as well as these potential challenges that it might include?
Sure, thanks, Fiona. I also would like to acknowledge I'm on Whadjuk Budja Noongar country and pay my respects to their elders, past and present. Yeah, so the benefit, I think, is essentially it's a triage. It's a helping with prioritization, and some of the points that Gabrielle mentioned and Tegan mentioned as well, in terms of you've got a whole stack of risks, you've got a whole stack of things that you need to deal with, and a human rights impact assessment or the due diligence process provides a principled and informed basis on which a company can say, all right, this is how we are making our decisions and how we are acting, as opposed to perhaps responding to whatever the latest thing that's blown up today, or a social media, you know, firestorm, or the you know, the wishes of the CEO. So that helps the prioritization, and we can think of the complexities. So for instance, when you know, 2019 and COVID was really hitting the Australian scene, and companies were faced with very difficult, you know, do we open, do we close, impacts on workers, impacts on customers, and when companies go through the due diligence process for modern slavery, at times they will uncover issues in their supply chains where impacts do arise, and how do you respond to that? Some people say you should just cease straight away, just stop, and that's it. Well, that's one option. That will have its own impacts from other workers or people who are also relying on what you are doing. So I think, as Gabrielle was saying, that the due diligence process helps by saying to a company, you look at the risks, whether they're sector risks, geographical risks, product risks, you look at these, and then in terms of prioritization, you're looking at, well, what's the scale of the different impacts that arise? What's the severity of them if they occurred? What's the reversibility of them? And it helps, I guess, inform that decision making for the company. And on the other side, for communities, for unions, for workers, that due diligence process then informs what you should be expecting of the company.
Thanks very much, John. And I think you've kind of balanced that really well in terms of the various stakeholders. Tegan, I might come back to you then. I have two questions. One is, and it relates to something that Serena said, which was that actually the good reporting entities are already doing this. So I just wondered if you had any thoughts on that. So human rights due diligence is certainly something that we do see in some of the modern slavery statements. So if you'd like to comment on that. And also, what do you think businesses might say in response to a proposal for stronger legislation such as human rights due diligence?
Good questions. In terms of human rights due diligence, yes, Serena's absolutely right. There are a lot of organisations that are already taking steps. And some of that's led being global entities. There's multiple, I guess, voluntary reporting or voluntary disclosures that these organisations like us choose to be a part of. And they're moving really rapidly. And I think some of that has been the driver of legislation in the US and the talk of an EU standard, as well as sort of the individual country standards that do exist across the European region. It's good to see so many getting ahead of it. It certainly is interesting reading the reports when people start to benchmark and compare them in terms of the materiality and what's in those reports. Certainly there is no clear expectation in Australia. So it is a comparison based on a set of parameters that are taken by whoever's writing the report. In terms of forming up the legislation, we certainly took part in the review by the Governor General's office, which many entities did. And I'm certainly an advocate for harmonisation across the structures. I feel like reporting season gets longer and longer every year. And the challenge with that is it means that companies end up spending a lot of time reporting and have less time and less resources to actually impact change. And certainly the intent of a lot of the acts is to not run away, but it's to look and find and seek to go on a journey. And so what would we be looking for from the government if they're going to go down this pace? And certainly it's something that we talked about with the Governor General's office. My personal view is I think the government has a big role to play in awareness and training. As we move down through supply chains, we certainly go below that $100 million barrier pretty quickly. That means that companies' resources also diminish in terms of the people. It's someone else who's already got a full-time job is likely to be asked to have a look at CSR or ESG on top of their day-to-day. So to have some form of training, education, awareness programs. Certainly there was some software that was developed in the US under a previous administration to help consumers understand their supply chain. And while it was generic, it's really valuable information to help peel back the layers, allow you to focus where the risk really is, where you can make an impact. And that extends across every business. You don't know what you don't know, and I think that becomes even more important when you move down that supply chain.
Thanks very much, Tegan. And these are very similar themes to what we've found in our research as well, and particularly the need for support and education and information. And Serena, that might also relate a little bit to your point about being reasonable in terms of expectations, because if people aren't supported and don't have the information, then we can't really expect high performance in areas that are not well supported. Gabrielle, could I come back to you and just ask for your sort of overview of what trends we're seeing globally in terms of the broader regulation of business and human rights?
Yeah, of course, Fiona. I'll be brief so that we have some time for the good discussion. But I mean, as other panelists have noted, the direction of travel is very much toward implementation of mandatory human rights and environmental due diligence laws. That is very clear. In the next 5 years, these laws will be enforced in Europe, but they'll have a wider impact, as I think we've kind of alluded to a little bit over the course of this panel. The EU directive will have a degree of extraterritorial effect. It will capture not only EU companies, but certain classes of non-EU companies. But in addition to that, it will require the companies captured to conduct due diligence across the entirety of the global value chain, with some limitations, which we can discuss perhaps in the discussion portion. But that is certainly the underlying kind of philosophy of the law, is to impose obligations on the largest companies in the hope that they'll bring along their business partners with them, and then kind of elevate improvement across the global value chain through direct obligation. There are also mechanisms in the law through which a very broad range of stakeholders can bring complaints to a company or a regulator. So that's stakeholders, again, globally. It's not just stakeholders in the EU. And then lastly, we also have a civil liability mechanism in the law, which will be accessible to in respect of impacts that occur, again, across global value chains. So this will have, I think, a much broader impact. And in addition to these kind of direct and indirect extraterritorial effects, these laws will also serve as inspiration for other legislative developments elsewhere. And we're already seeing that. I think Freya mentioned New Zealand, but we're seeing developments in Canada. Colombia is developing its own draft law, but also a model law for the use in the broader LAC region. We're seeing developments in Kenya, where there are commitments in the National Action Plan on Business and Human Rights to implementing a mandatory due diligence law. And so this is really not just a European project. This is a clear trajectory. And companies need to prepare for that, frankly. And states need to assist them by evolving their legislative environment to align with this global trend. And I think that this review of the Australian Modern Slavery Act is a really timely opportunity to think about that and to think about aligning with this broader global trend.
Thanks so much. And I think that's really useful to get that broader context, because it isn't just a few countries who have decided to introduce these types of laws. It really is what we might call a legislative trend, and it really is spreading around the world. And interestingly, I saw that the New Zealand government's consultation, the finding from the submissions that they received was that there was broad support from those submissions for human rights due diligence. So I think, again, as our close neighbour and trading partner, etc., it would be really interesting for us to keep an eye on developments there too. All right, look, thank you everyone. I think we've already got some questions, so I'm going to move to the Q&A. And
Fiona, if I may, I've had a look through the questions, and I think there's three that are all touching on a similar theme. So there've been some questions about what's the potential exposure or liability of companies making statements. Someone's asked, are there good examples of how boards or managements deal with this? And then also, how do you deal with people who are just avoiding this completely, and maybe there's a black market thing and they don't care? And I think I see the three of these coming together in this way. Due diligence, whether it's a human rights due diligence or a modern slavery, complying with the Modern Slavery Act, is not a matter of simply just writing a contract and saying to the person who gives you products, make sure you understand the UNGPs, don't you? We're not changing our terms, we're not changing the conditions, just sign that and I'm good, I've done everything I need to do. That's not going to get you there. And so the idea of proper due diligence of the lines that have been explained here is saying that it requires companies to better examine and understand their supply chains. And that's a way that I think some of these other difficulties that will be picked up, because somewhere often something that's been made on a different supply chain is going to turn up somewhere. And so we're hoping, I guess the theory is that if other people are properly understanding where they're getting products from, it will be perhaps addressed a bit there. And the point, I guess the point on the exposure, are you worried about making a statement, oh, we've found some difficulties in our supply chain? Yes, that needs to be thought about, but equally for big companies these days, how can you not afford to look at that? Because most companies, if you are looking for government business, if you're filling in your modern slavery statement, you're saying that you've had a look at this, so you're making that representation that everything's okay anyway, so you might as well actually look and make sure that that's the case, because that will be misleading if you don't do otherwise. But yeah, I don't have I've seen some bad examples of, as I say, contracts saying it's all your responsibility. Tegan, I don't know if you can talk through maybe some of the complexities that are looked at and how you work through that on a company side.
Yes, certainly, John. You're right. It's not something you can just pass down the supply chain. You can't put a little clause and walk away. And certainly, I think if you look at some of the companies that are making genuine progress and genuine efforts in this space, they're not doing that. The key to this, in my view, is partnership. So you have to set up a program. You have to set up a journey with your suppliers. And at some point in time, it's going to require some incentivization. So whether you set minimum requirements, minimum scoring, and that's integrated into your decision-making and supplier selection process. And certainly, at some point in time, it becomes part of the commercial negotiation process. Much like you can get better interest rates with CSR and ESG loans based on your credibility. I think there's a commercial value of this to be integrated into the process, but we've got to go on that education journey first and that partnership.
Thanks for that, Tegan. Gabrielle, did you want to come in there as well?
Yeah, I think just to address the litigation risk, the question which arises from disclosure, because that's certainly something that's been a live issue in the context of the EU developments, and certainly a lot of issues that have arisen because of the line of authority and a number of cases in the UK. So, for example, the Vedanta case that was brought to the Supreme Court in the UK established this principle that a parent company can be liable for in relation to acts of subsidiaries where it has, for example, represented that it's instituted a policy framework that would regulate the sort of environmental damage, for example, but it doesn't in fact do so. And so there was a real question that was being raised in the context of those proceedings and the developments there in the UK around whether or not this would then discourage parent companies from engaging with their subsidiaries and really improving their performance. The case itself considered a UK parent company, a Zambian subsidiary, which was responsible for fairly wide-ranging environmental damage in Zambia. And so there's this kind of constant tension. But I think one of the things that can be a way to address that is by requiring the conduct of due diligence, because I think that if you have these kind of potential exposures, you can address those, I think, by conducting due diligence in line with the requirements of the law. And that can be not just a kind of a thing that could lead to exposure, but rather a shield. And so the sort of conduct of effective due diligence, I think, is one way of managing these kinds of risks, because while I've referred to the development of the due diligence law in the EU context, it's not the only thing that's happening in terms of business and human rights regulation. There's also developments around corporate sustainability reporting and the development of a new set of European sustainability reporting standards, which would require very detailed disclosures about due diligence, about the impacts that have been identified on a kind of comply or explain basis, meaning that you can't just simply decide that a particular reporting standard isn't relevant to you. You have to kind of explain why it's not. So I think you're seeing these parallel tracks, because you can't simply rely on one particular kind of tool in the arsenal to fully address human rights harms which might occur from business-related behaviour, I think you need to attack it through requiring due diligence, through requiring good disclosures and encouraging transparency. And then, as I think it was Freya who mentioned, other trade and import control levers, such as restrictions on the import of goods produced using forced labour. They all need to be considered in the round. And I think that if those are well balanced, it can mitigate litigation risk exposures if you are conducting due diligence in the way that you should be. That can very much be a shield.
Thanks very much, Gabrielle. Freya, I might come to you, and I'd like to ask you to pick up on that question of disclosures, and obviously whatever you would like to say about it, but also I know that, for example, when you do your work on assessing modern slavery statements, that's something that you take into account. So you might have some comments on that. And I see there's a question as well about the relationship between things like the Modern Slavery Act and import bans, and whether these should be somehow more linked or coherent. So you might like to address both of those, and then if anyone else wants to come in afterwards.
Yeah, sure. So I think in terms of the litigation risk question, I agree with a lot of what Gabrielle was saying about if you have a due diligence obligation that accompanies disclosure requirements, essentially, in a way that's a protection from greenwashing type claims. And in our research around modern slavery statements in the first round, there was a very small percentage of companies that did disclose instances or allegations of modern slavery statement, 8%. But what we did find was that among that 8%, largely those companies also scored highly in terms of the way in which they describe their human rights due diligence processes. And so that goes to show that if you have those processes in place and are actively looking to identify your risks and then disclosing that, that shows you have effective processes because you're finding the things. And then also every single one of those companies explained how they addressed those allegations or instances in their statement as well. And so I think that is the trend. If you disclose, then you should probably have an answer as to what you're doing to address those risks. And that isn't the case across the board. I have seen statements, I think, as Serena might have mentioned, where there's clear risks identified, no action taken to address them. And that's the standard that's, legally set at the moment. You can do that and it's fine under the current legislation. But creating an incentive for companies to look further and want to know what's in their supply chain rather than, putting the contract clause in, pushing it down the supply chain and avoiding responsibility is the direction that we want to go. And that's the direction that responsible companies are already going in. And we're seeing evidence of that. On the import ban question, I think it's a kind of missed opportunity that the current Modern Slavery Act isn't including consideration of that measure, and I'm sure that it will be considered by the government in good time. But there's obviously quite a lot of support within Australia and within the Australian Parliament for those measures. Last year, a law was passed in the Senate to ban all goods made with forced labour regardless of geographic origin, and that's now in the House of Representatives and hasn't moved. But I think what it shows is that it's a possibility here as well. And I think that in terms of what the US has done, we have seen those import control measures being quite effective and actually driving change deep within supply chains in supply countries where there's been higher risks of modern slavery and more influenced by US regulators in trying to improve those standards. And so that's another tool that we could add to our box of legislative reforms, I think, here in Australia, but the current review isn't taking that into consideration at the time.
Thanks so much, Freya. And I think this question of a really good question. We've got these different areas of the law that are trying to deal with the same type of issue. And as you say, the import ban hasn't passed yet. But Serena, I might put a related question to you, which is whether we think it would be useful to have an anti-slavery commissioner to draw together the different strands of this quite complex issue.
Yes, we think it would be very useful to have one. And I think everyone's in pretty broad agreement here in Australia on that. I think the government's committed to having that. But I do think that the resources committed to that anti-slavery commissioner are really, really important in order for them to be able to take effective action. And in terms of, I think a lot of people say, yes, we want an independent anti-slavery commissioner, but there hasn't been too much discussion about what that actually means. And I think looking to the UK model is quite a good model in terms of having that independent role that's designed to hold the government whole modern slavery response to account. So looking at things across from whether it's import bans, modern slavery acts, government procurement, Freya mentioned trade agreements before, what are the modern slavery chapters going into the trade agreements, our aid funding, all of these things I think need to be considered as a whole. And the flip side to that is also victims, survivors. How are resources being channeled to actually help the people that are found in Australia? And there are cases in Australia, and how are they channeled? We don't have a national referral mechanism here. I think, the coordination of that response to make those services available to people who have been in that situation, we really need to invest more in that. So as businesses up their game and identify more situations and more people that need to access those services, we also need someone who's empowered to oversee that response.
Yeah, very, very much in agreement there, Serena. And I think, potentially if we did move towards a human rights due diligence model, there's no reason why the anti-slavery commissioner couldn't also have a grievance or complaint mechanism function like the Australian Human Rights Commission or other similar bodies who have that educative function and all of that, which we've identified as a need, but could also do other things. Thanks for that. Okay, so we've got some other good questions. Kit has posed a question about the businesses with the turnover of under 100 million. I think this is a really good question because we know that either in Australia or overseas that's where we are going to have a lot of high risks. And yet those businesses are not covered by the Act, unlike the New South Wales Act, which does have a different threshold. Tegan, as the designated business representative, what are your thoughts on what happens in those businesses that are under that threshold? I suppose the idea is this sort of trickle-down effect, but I know that can be a problematic way to tackle the issue.
I think you can come across a few different scenarios. You have the scenario where businesses want to learn, want to grow. They've got their own policies, so that they're happy to go on the journey. You've got the businesses that will say, well, no, this is not my problem. I don't have to report on it. And then you move down into your really small enterprises who just don't know where to start. They don't know whether they're for, whether they can do it, they can't do it, they should do it, they shouldn't. And this is that education, I guess, gap at the end of the day. Big, larger organizations, leading ones are certainly looking, they're peeling back the layers, they're having the conversations, they're starting the education journey. But as your supply chain spans out into your tier 2 and tier 3, that becomes a really challenging conversation. And, even just questionnaires, depending on the business, they don't know who to send it to. Does this belong with finance? Does this belong with health and safety? Does this belong with the operations on site? And depending on your business, you end up creating, a lot of effort and energy around, filling out a form, answering a survey, rather than, things that can actually make a material difference. So understanding, driving supplier behaviour, incentivizing your supply chain to put their own policies and governance in place.
Thanks very much, Tegan. Another good question from Penny, which is around sort of what tangible actions we might recommend that are good practice. And there was another question which we may have touched on a little bit, which was how boards are actively managing their obligations, and maybe sort of information asymmetry between non-executive directors and senior executives, particularly maybe in those large complex organizations. So I'm just opening that up to anyone who'd like to address those questions.
Fiona, perhaps move on. Before we move on to that, I might kind of just field a response on the personal scope question, because I think there is this kind of ongoing sort of debate around that, kind of certainly in the European context, of how to kind of encourage broader engagement with the process of due diligence beyond just the companies who are captured by the law. Because I think SMEs are specifically excluded from the European Due Diligence Directive, and although member states may elect to go a bit further when they enact their own national laws, that has, certainly been a tension point in the negotiations around the directive. And I think what the directive aims to do is to kind of use a logic, as I sort of mentioned before, of applying direct obligations on the very largest companies, in the hope that they will then kind of essentially a kind of trickle down model where they bring along kind of business partners with them, but including through requiring contractual compliance with a code of conduct, which are then required to cascade along to their through their business relationships. Whether or not that's a kind of useful model, or whether or not it would be more useful to expand the scope, personal scope itself, is a debate that I think is ongoing. But just to say, I think different, regulatory models might be appropriate in different circumstances. But I think at least certainly the initiatives that we've seen so far, and I think that the Australian Modern Slavery Act, I think, is one. There's very much that sort of logic of applying obligations directly on the very largest, in the hope that this will kind of elevate compliance along a wider group of companies who may not be directly captured.
Thanks very much, Gabrielle. So yeah, Aisling's question about the board and Penny's question about good practice, if anyone would like to take those. Serena, were you going to come in?
I was, yes. And yeah, I agree with Gabrielle on that previous point. And I think we've actually had companies say to us, and Tegan, I think you might have been part of this conversation, big companies would actually find it easier if the scope of the Act were extended. So if the revenue threshold was dropped to 50 million, because then all their suppliers have to comply. Like, they do face real challenges when they're saying to their suppliers, look, we really care about this. We want to see what you're doing. We want to see, do you have a grievance mechanism? And they're like, sorry, we don't have to comply with that. So unless they've got real leverage to push those companies to do it, it's a challenging conversation. So expanding the scope would actually help a lot of big businesses. I think on the director's point, I think I put my hand up. This is very front of mind for me. I'm doing a director's training course this week, so I have been thinking about directors' duties nonstop all week. And I think, that specific question around asymmetry between non-execs and directs, I mean, you've got that for any issue that you talk about. I don't think this is any different. And I think you just apply those same processes of inquisition and making sure you've got the right information, the right KPIs set, and that you challenge those on a regular basis. So yes, it is complex, but I don't think that it's, that much more complex than other issues like health and safety or bribery and corruption that involve, cross-border activity, complex supply chains and everything else. So I think it is really important, whether you're an exec or non-exec director, that you keep yourself informed, that you know how your company is monitoring it, how it's reporting back up to the board, because it is ultimately the board's responsibility to sign off on that modern slavery statement at the end of the year, and to make sure that it's not, you're not misleading anyone by putting things in that statement that aren't true. So yes, there is, I understand it's challenging, and it feels more challenging because it's not even your company, it's the suppliers and extended supply chain. But I think you just manage that in the same way that you manage other issues.
Thanks for that, Serena. Freya, did you want to add anything on the good practice tangible actions question from Penny?
Yes, so in our report, Paper Promises, which I'll put a link to in the chat, there's quite a lot of useful guidance on what we see as forming effective action against modern slavery risks. And there's also, in relation to the 4 sectors that we looked at, there's sector-specific recommendations for sort of meaningful ways in which companies can take action to mitigate some of those specific risks that we saw in those 4 sectors. But I guess at its heart, it's about knowing and showing that you're identifying the right risks and taking steps to prevent and mitigate and use your company's leverage to try and change exploitative practices down the supply chain. And things like companies examining their own purchasing practices and seeing whether or not they're contributing to unrealistic deadlines, order cancellations, delayed payments, or negotiating the price so hard that it isn't possible for a living wage to be paid at the other end. Things like that. We've also looked at issues around engagement and collaboration with affected workers or union representatives, civil society organisations working with those workers to ensure that the processes and policies that companies are developing are actually informed by the people that they're meant to be benefiting. And also just the basics, like no one should pay for a job, ensuring that no one in your supply chain is paying recruitment fees or being held in debt bondage conditions, and having checks around how you actually implement those policies.
Thanks so much, Freya.
Can I just add one quick thing?
For it,
I really loved Freya's point there. She said, using your leverage to try and address these issues. So it's not the UN guiding principles are not a strict, look, if you find anything in your supply chain, you're done. It's not saying that. It's saying be aware of it. And where you have leverage and you understand maybe the conditions and the issues, then use that. And if you've addressed that to the best that you can, then you've met what's expected of you in the UN guiding principles or the OECD guidelines as well.
Thanks so much, John. I think that's really useful to kind of keep it real in terms of what can be managed. I realized we had a question early on from Tim, and I think Tim's point is really about the business model that we have and whether this focus on modern slavery basically legitimizes the types of practices that we rely on under this existing business model. Does anyone have comments on Tim's question?
Yeah, I might have a stab at that. Just to say, I think that there is a real, if you start enacting these laws without a sufficient focus, I think as Freya alluded to, on the sort of the needs of rights holders and placing them at the center, then that I think will often be the result. I think that will be the danger. So to take an example from the EU context, there's currently a process in place to implement a ban on the import of goods produced using forced labor into the EU. And one of the things that a number of actors, including the European Parliament, has really strongly called for is that law should include remediation mechanisms and obligations to, repay recruitment fees and all these kinds of issues that Freya's kind of referred to in her response a moment ago. However, that hasn't found its way into the law. And so ultimately, because there is no focus on the need to, there aren't really strong incentives to engage with the underlying issues and the kind of underlying conditions of workers working in conditions that amount to modern slavery. It means that essentially this is really just a tool to protect a poor EU consumer from accidentally buying something that was produced using forced labor and feeling terribly bad about it. Like that's essentially what it does, as opposed to really engaging properly with the kind of underlying conditions and ameliorating the conditions for rights holders who are on the ground working in these conditions. So I think that, certainly if you don't kind of place right holders at the center, really think about kind of how to address the impacts on them, how to remediate kind of harms which occur to them arising from these kinds of risks, then that's, I think, going to be the result. So just to share that.
Thanks very much, Gabrielle. John, I have a follow-on question for you.
Well, can I add one thing just to that?
You start,
this question is this question is often bringing up this. Look, what is the role of the state? What is the role of legislation? And to some degree, if it's all the responsibility of companies, can states say, "Great, we'll just withdraw from this area"? I guess the one observation you might make, to the extent that a state's law and regulation is below the international standards and they're allowing companies to operate, those companies may be putting themselves in a position there could be a complaint to a national contact point to say, you're not meeting these international standards.
So basically, we should align with those international standards because those are what are expected, and companies could be brought to the AusNCP.
Certainly asked to explain whichever contact point it is.
Yes, true. I wanted to come to you, John, as well, because I'm really struck when Gabrielle is speaking, you're based in Europe, the really strong focus on rights holders. And I'm obviously from Europe originally as well. And I'm wondering whether, I mean, Australia remains the only Western democracy without a Bill of Rights, a Human Rights Act, and obviously there are campaigns underway, including here in WA, but also nationally. John, or open to others as well, do you think that's a barrier for some of these potential developments that we're discussing here? That certainly the terminology is what struck me. Is I don't hear in our discussions here in Australia the terminology of rights holders being used in a very sort of normalized way in this type of discussion, because we don't have a culture of rights in that same sense. So John, do you have any reflections on that?
Yeah, it's certainly the phrase human rights is used less, I would think. I guess to some degree, I'm a little more, look, the important thing is, and I'm not sure who said this, what is actually happening to address the impact? And whether that's called, whether you call that your human rights policy, or you call it, you know, if it's in relation to Indigenous issues, your reconciliation policy in Australia, or whether it, you know, the law requires it, or whether it's your company policy or whatever, to some degree, I'm not as excited about that. I'm excited about, is the impact actually being addressed? I don't think, you said, is it a barrier? I don't see these two as necessarily conflicting or prejudicing each other. I don't think it should be a barrier.
Interesting, thanks, John. We had another question from Kit, which was around the intergenerational trauma and the history of slavery and what's being done within the Act to address the trauma, healing, rehabilitation and reconciliation needed. So I'm going to open that up to the panel. I'm going to maybe steer you in the direction of talking about remedy. And I'm going to ask you, and I think perhaps Serena and others have already talked about whether we've got a sufficient focus on victim survivors. The one other thing I'm just going to flag is the work of a colleague, Professor Jane Lydon here at UWA, who has a project on the British legacies of slavery, which looks at slave owners from the UK who were paid compensation when slavery was abolished and then moved to Western Australia and used that money to sometimes implement similar practices. So just from that intergenerational perspective, I think that would be really interesting to have a look at. But can I open up that question of remedy and how much of a focus we have in this work on victim survivors?
I'm happy to do a first stab at that question, and it's a really important one. From our perspective, you know, the Modern Slavery Act needs to be about the people that are affected by those practices, and at the moment there's no pathway to remedy for people who are in those circumstances. And so I think that the movement towards incorporating civil liability in the European directive are really important and definitely should be taken into consideration in our current review here of the Modern Slavery Act, so that people have a right to remedy and can empower themselves to bring a claim where they have been subject to those practices and there's been no efforts to mitigate the harm that they've been faced with. And more broadly, I think, and aside from like legislative reform, when companies are thinking about remediation, what I've seen from many statements that I've reviewed is that often remediation is seen as like a corrective action plan with a supplier, or having a discussion and then there's an agreement reached and then it's never revisited again, but it doesn't necessarily talk about remedy for the person who's impacted. And so I'd encourage anyone who's preparing statements or responsible for your policies within companies to look at that question of your relationship to the people that are impacted, whether or not you can contribute towards trying to restore that person to what they would have been without that, you know, that egregious impact to their human rights, but also whether there's leverage to engage with your suppliers to ensure that the suppliers remedy the situation for the person, because I think the person isn't very much front and center of the conversation around remedy at the moment, and that needs to change.
Thanks very much, Freya. Would anyone else, Serena, you wanted to come in?
Yeah, I completely agree with Freya on everything there. I think I'd add to that in terms of, the practical challenges for companies. I agree they need to be thinking much more about what is the impact on people. And then once I discover that impact, what's my role in remediation? And I think what we've discovered from working with businesses is that they actually don't know what to do. If a case is discovered and, regardless of how serious it is, it might be in another country where they don't have relationships. They might not know what the legal environment is there or what the modern slavery risks are. It's really important that they educate themselves on that before it happens. I think it's like any crisis management plan that you would have for any other issue. They need to have that. And that's something we actually worked on with a number of businesses, including Tegan at Alcoa, to design a response and remedy framework to really look at what do you do when you find something, and how does your organisation have that crisis management plan in place. And, I think one of the key things that came out of that was developing relationships with NGOs and worker rights organisations and others that are in the position to help the people who have been impacted when it happens, because you as a company may not be in that position. In fact, you most likely won't be. And there will be all kinds of barriers from you being able to provide that effective remediation. Financial, sure, but you need to make sure you've got the relationships in place on the ground so that you can actually step in when something has happened. And I think, we'd love to see a recognition of that in the laws as they come in, and indeed through the anti-slavery commissioner's role, in playing that education piece role with companies.
Excellent. Yeah, and thanks for mentioning the resources. I think that's a really useful framework that was developed. I want to really just briefly take a last question, which is a really excellent question from Mark, around social media corporations, whether they should be required to monitor and remediate cases of the use of their platforms for sexual abuse, torture of children, other human rights abuses that the platforms facilitate. And obviously not a hypothetical question, really a really significant issue. So would anyone like to speak to that one?
Yeah, maybe just to say that, yes, this is a really, I think, one of the things that we're developing at the moment at the Institute is a project looking at what meaningful human rights due diligence looks like in the downstream part of the value chain. So it considers exactly these kinds of issues. What responsibilities a company might have for kind of use of their products or services, and that sort of thing. So I would say that, yes, there is a responsibility there. But I should also say that I think that the issues that arise in the downstream part of the value chain are going to need to be managed, I think, in a slightly different way to the way that we manage kind of issues in the supply chain. I think that we now, I think it fairly well socialized the idea that companies have responsibilities in relation to impacts which occur in the supply chain, whether that might be modern slavery risks in production and that sort of thing. But I think that this other part of the value chain, this downstream part, I think is not very well understood. And although you do have certain sectors where there are much more developed practices, like the tech sector, for example. I think that there are a lot of tools and resources there to assist tech companies to grapple with exactly these issues. That doesn't necessarily, although it hasn't necessarily found its way into other sectors. And so I think we're at the moment exploring what kind of cross-sectoral guidance we might be able to develop on that front. But just the short answer, yes, they should be considering those impacts, would be the response I would give.
Thanks very much, Gabrielle. So we've got a few minutes left, and I'd just like to pose a final question to each panelist. So just to take a couple of minutes and tell us, well, first of all, anything you didn't get a chance to say, please feel free to say whatever you'd like to contribute. But also, what do you hope to see as a result of the Modern Slavery Act review? What's your wish list? I'm going to start with the order that you're on my screen. So Freya, I'm going to start with you.
Thanks. So I think to wrap up, no business should be profiting from the exploitation of people in their supply chain, and that's what the Modern Slavery Act is aimed at addressing. And so I think in order to strengthen the Modern Slavery Act, we're looking for 3 key reforms. Firstly, the Modern Slavery Act should be reoriented so that it requires companies to take action to identify and address their risks, rather than reporting on what they're doing to identify and address their risks. And so incorporating due diligence is a must, and we hope it will lead to much more change than what we've seen over the past 3 years of the Act. Secondly, we'd like the mandatory reporting regime to be made truly mandatory, and that would involve the imposition of penalties for non-compliance and other measures that have been mentioned by other panel members tonight. And also connected with that, there needs to be better oversight and enforcement of the Act, including through the appointment of an anti-slavery commissioner that's independent. And lastly, there needs to be access to justice for people who are impacted by modern slavery and labour exploitation, so that they are empowered to seek remedy where their rights have been abused. And so I hope that the Modern Slavery Act review considers these issues, and we see a stronger act in the new year.
Excellent. Thank you, Freya. John, you're next on my screen.
Thanks, Fiona. I just put up a link to the OECD general guidance on due diligence, and I think that's an answer to this question. I think there's some concepts in there that could possibly be used to inform greater maybe guidance for companies, or pointing that way from the legislative basis in Australia. And it also has some of the concepts, like it slightly unpacks to more degree. If you cause and contribute, this is your responsibility. If you're linked, it's slightly different. But exactly as Gabrielle says, I think the broad concepts are there. I'm looking forward to them being worked through, whether it's cases or explanation, a bit more detail of exactly what that requires. And the social media question is a very good example of the work that needs to occur here.
Thanks very much, John. Gabrielle, you're next on my screen.
Thanks, Fiona. And I think I just echo everything that Freya just said. I mean, I think that you already have a framework here which requires reporting, and which is roughly in line with the expectations of the UNGPs and OECD guidelines. I think it would be a natural evolution in the context of this review to think about actually requiring action. This is very much in line with the global trends in regulation that I've kind of noted there. And I think, but I think also worth considering as well is that there is no one silver bullet for these issues. Like simply implementing a due diligence obligation is not going to be enough. And I think I alluded earlier to, the fact that this is not the only game in town at the EU level at the moment. There is, huge reforms are forthcoming in relation to corporate sustainability reporting, requiring reporting against fairly granular standards. In addition, efforts, we haven't sort of talked about the role of investors here so much, but there's huge efforts to engage with the investor community to direct finance flows toward environmentally and socially sustainable economic activities through the development of the green taxonomy, as well as the sustainable finance disclosure regulation. So there's quite a lot happening. And I think that it's also worth reflecting what other supporting measures are needed from other regulation in the Australian context to really support the objectives of the Modern Slavery Act, and to ensure, as you say, that rights holders are placed at the centre, and are taken care of and have access to remediation where harms occur. So I think those are all critical elements.
Thanks so much, Gabrielle. Tegan, you're next.
Thanks, Fiona. From an execution point of view on the legislation, certainly alignment globally. There's a lot of conversation around wanting to make sure that people are taking action, that are doing due diligence. And as a practitioner who is implementing the Act, to be able to spend less time reporting on several different versions and slices, and having to create like specific viewpoints and landscapes, because the different angles people want to look at the problem. If we had some harmonization in that space, it would give us greater bandwidth to actually look a bit deeper, affect change, make sure that a correction active plan is not something that just sits on the shelf. It's something that you can pare back Certainly at Alcoa, you know, our execution of this is very much aligned to our values around care for people. So it's something that we do commit the time to, and we're growing in our approach, and it's a learning journey for us as much as it is for the suppliers and the people that we engage with in our supply chain.
Thanks so much, Tegan, and really useful to get the business perspective in terms of what it means on the ground. Serena, you're the last speaker.
I really don't think there's anything left to say there. I completely agree with Freya in terms of, what we need for the review for this Act, and definitely Gabrielle in terms of, we can't just focus on a due diligence requirement. I think whether it's import bans, trade agreements, all of the other things we've discussed today, a human rights charter, I think, with some of the side discussions going on, and then also with Tegan in terms of implementation. At the end of the day, there's no point having a beautifully drafted law. We actually need to make sure that businesses can implement it and that they know what to do once something happens. At the end of the day, the kind of key KPIs we want to see is that they are finding problems in their supply chain. It's counterintuitive, but we want them to find it and we want them to respond. And we need to really do whatever we can to make sure that happens, and really put people and rights holders at the centre of that. So yeah, there's my long shopping list, but it's just repeating, I think, what everyone else has said.
Thanks so much, Serena, and that really concludes the conversation this evening. I was really struck by, I think it was Gabrielle who talked about this being a natural evolution. And certainly I can see how the Modern Slavery Act was a useful first step, and it helped raise awareness. And there's lots of learning, as Tegan has discussed. And this would be a logical next step, I think, for Australia within this globalized business environment that we're in. I would just like to thank everyone. I have really learned a lot from all of you. I've really enjoyed hearing your perspectives, and to our attendees who posed really insightful questions, thank you. Big thanks also to Shamit and Rebecca Ray at the UWA Public Policy Institute, who did a wonderful job in organising the webinar for us. I do understand that there will be a recording which will be available online at a later date, and it's there as a resource for people to use, so please feel free to do so. And that's it from me. Thanks everyone, and have a good evening or have a good day wherever you are.
Thanks all.
Great. Thanks very much, Fiona and all. Thanks.
Thanks everyone. Bye.
Thank you.